Streaming live via the internet, welcome to ISP Radio, your weekly source for ISP-related news, events, and interviews with industry experts. If you deliver internet via fiber optic, wireless, coax, or any other way, you're in the right place. Chat live with us weekly via ispradio.com every Wednesday at 11 a.m. Central Time. And now a brief word from our sponsors. Link Technologies, providing ISP consulting, support, and hardware for wireless ISPs. TowerCoverage.com, providing online RF coverage maps. And now your host for ISP Radio, Steve Grabiel and Dennis Burgess.
Welcome to another edition of ISP Radio. I'm your host, Steve Grabiel, broadcasting from Moriarty, New Mexico, and Dennis Burgess is producing the show and co-hosting the show from St. Louis. Not much going on out here, just wrapping up this fiber optic project. I got probably a week's worth of digging to finish up, and then everyone's added that wants the fiber optic service, which is real pleasing. And then off to our next venture, trying to add more people to our fiber network. Wireless is keeping up. Had a massive power outage yesterday because a few raindrops fell on the electrical system, and they went down. The co-op was scrambling to get it up. I think they said 9,000 households are down.
A few raindrops? That don't sound good.
Yeah. So the power company got that back up, and it was interesting. We hardly got any calls about it. I think that people are understanding if there's no power, there's no net.
But it's wireless, man. It's wireless. It should work.
I know. So what's going on in your neck of the woods? Out here, it rained a little bit last night. We're really like the rain. It was nice, and it's kind of cloudy and overcast. Probably going to be about maybe 60 degrees today. Don't have a whole lot on deck to do work-wise, but it's just another day in paradise. So, Dennis, what's going on in your neck of the woods?
Well, I've been working on a massive email migration that we've been really working hard on. Something like 80-something domains. It's really actually working really well now. We have not moved a whole bunch of domains yet, but we're getting ready to. So, all of our migration system is all working. Everything's working. So we're gonna let it go and start moving some mailboxes over. Other than that, we've been busy. This week has this week and last week has definitely proven to be a busy week for us in the technical support department here at LinkTex. Other than that, we are at another trade show. We have lots of good stuff coming up. For those of you that don't know, Microtech Mum is coming up. I believe it's in May. It's at May 24th and 25th. It's literally the week before, Memorial Day?
Yes, sir.
I think so. So why they planned it there, I don't know, but hey, whatever. So we have that coming up as well. Otherwise, Wispapalooza still a good little ways away, October. Otherwise than that, man, we're pretty good. We are graced to have Jenell here.
Thank you, gentlemen.
There she is.
I'm here.
We have Jenell Trigg. She's a partner at LermanSenter, and LermanSenter is WISPA's attorneys fighting the battles for us in Washington. And I was at Wispapalooza last year and sat in on a breakout session that Jenell was leading on privacy policy, and I thought, hey, what a better way to get out what I learned here and see if there's something I could learn above and beyond what I learned at Wispapalooza. So Jenell, welcome to our show. We appreciate you taking the time to be on our show. So why don't you tell us a little bit about yourself, and we'll get into privacy policy, and I believe you had some new news.
Certainly. Thank you, Steve. Thank you, Dennis. Everyone, I'm delighted to be here. As Steve mentioned, I am a partner and also chair of the Intellectual Property, New Media, and Technology Practice Group at LermanSenter here in beautiful downtown Washington, D.C., a crazy place right now. I am former FCC, as well as the former Assistant Chief Counsel for Telecommunications for the United States Small Business Administration, their Office of Advocacy. So I have advocated on behalf of small businesses for my entire legal career, which is really relatively short. I am a relatively new attorney, only been practicing for 20 years. Prior to that, I had what my mother calls a real job. I was sales and marketing for broadcast stations across the country, most likely in Chicago as well as Baltimore. So I have a real firsthand understanding how FCC rules and regulations can make your life miserable, and been working to try to avoid a lot of that. Breaking news indeed. As of yesterday, Congress passed what's a very rare congressional resolution of disapproval under the Congressional Review Act. They basically have eliminated the FCC broadband privacy rules. Those rules are no more, wiped off the face of the earth. It is unusual for Congress to take this step. But there was a great concern in both houses, both the House and the Senate, that these rules were so overreaching. In fact, I'd like to read a statement from Chairman Pai on this CRA, basically the Congressional Resolution of Disapproval. He says, "It is worth remembering that the FCC's own overreach created the problem we are facing today. Until 2015, the Federal Trade Commission was protecting consumers very effectively, policing every online company's privacy practices consistently, and initiating numerous enforcement actions. However, 2 years ago, the FCC stripped the FTC of its authority over Internet service providers. At the time, I strongly opposed usurping the FTC and the FCC's struggles to address the privacy issue of the past couple of years, along with its refusal to recognize consumers' uniform expectation of privacy, has only strengthened that view." Now, this does not change your status as a common carrier. That was adopted in the Open Internet rules, which has not been repealed. That's still in place. But the broadband privacy rules that were adopted just last year went into effect this January and have also rolling effective dates. These are the data security requirements, the data breach requirements. What's deemed to be sensitive information is web hosting, app usage history. That's no longer in place. So this is very good news for small ISPs.
Gotcha. So my question is that they issued a notice of disapproval.
It's called a Congressional Resolution of Disapproval. It's a very rarely used provision under an act which was passed like 1996. It's only been used once before and never before against a quote-unquote independent agency. So basically, Congress disapproved the rules and had to go through certain requirements by statute, but wiped the rules away.
Okay. So it just sounds like, disapproval means shame, shame, shame on you. And
it's not just shame, shame,
yeah,
shame,
it
shame,
actually,
goodbye.
Yeah, it actually repealed it, which is good.
So from a standpoint of a small business ISP with one domain and no apps, what does this really mean for me, Jenell?
It means you still have to have a privacy policy. Remember, you're still subject to the FCC's net neutrality rules, which means you're designated as a common carrier. And you're still subject to Section 222 of the Communications Act, which is the Customer Proprietary Network Information Rules. Also, let me emphasize that when WISPA was fighting on, we were fighting on WISPA's behalf to get these rules either repealed by the FCC or changed by the FCC. The entire ISP industry adopted what's called ISP Privacy Principles to give the chairman, the FCC, as well as consumers, a little comfort that we weren't just going to be rogue over a consumer what's called personally identifiable information. So we agreed to, ISPs, trade associations across the country, what's called ISP Privacy Principles. And these match what has been in place for decades. These principles match what has been required by the FTC and best practices for a while, which means you still have to have a privacy policy. And the basic things about a privacy policy, you want to manage your consumer expectations. You want to basically state what type of personally identifiable information, I'm going to call it PII for short, because saying personally identifiable information every time is a tongue twister. So PII, sensitive PII, you want to basically explain to customers what you collect, how you collect it, how you're going to use it, who you're going to share it with, and why, how you're going to keep it secure, protected from unauthorized use, and how long you're going to keep the data and for what reasons. That's the basic premise of a privacy policy.
Now, there has been some talk on, this is actually an operators group list. They were talking about how they have been selling anonymized data to various companies. Now, does this affect them being able to do that?
You can do that if you disclose it in your privacy policy, and if it's truly anonymized, or if it's not traceable, linkable back to the actual consumer. Basically, a lot of times ISPs, and this is not an unusual practice, this is a general practice in the industry, whether it's ISP, whether it's an edge provider like Google or Facebook, or any given website, or anyone who's offering content online or via apps. You can put a lot of customer data together in the aggregate and sell that general information, as long as it does not identify an individual consumer or subscriber or a customer. So if it's in the aggregate, if you want to say that 50% of my web traffic does XYZ, or they use certain algorithms, or they use certain websites, or sports fans, or whatever, you can do that. The best thing about the repeal or the disapproval of the broadband privacy rules, there aren't the more strict provisions that were in place about what you have to do when you anonymize data, what type of steps you have to take. As long as those steps are reasonable, and there's some industry standards as to what reasonable is, that should be acceptable. But you should disclose it in your privacy policy that you will provide aggregate information based on your subscribers, customers, however way you want to classify them, and that is disclosed to third parties. That's part of the basic disclosures in a privacy policy.
Gotcha. Just making.
Now, if I could just,
go ahead.
I'm sorry. Go ahead, Dennis.
No, I was just making sure that what they were doing was legal, and I know there was some scuttlebutt about it, about the current administration and having the laws that prevented that.
Well, it didn't necessarily prevent it. It just put standards on how you could do it. Again, the FCC's broadband privacy rules, again, which exist no more, had certain requirements. Information was based on regular, personally identifiable information or sensitive. And sensitive information under the FCC's definition included web history and app usage history, which is the fundamental part of what people are sharing online.
Sure.
So because it was sensitive data, a consumer needed to opt into it, which means that consumer needed to give you their approval first before you use that data. That put a whole different set of standards in place.
Gotcha.
But that definition of sensitive data exists no more. Please understand that there's still a such thing as sensitive data, and that's traditionally your social security number, driver's license, financial information, children's history, children's privacy, personally identifiable, PII, as well as geolocation. And sometimes it could also be health and medical information. That's sensitive under the FTC's definition, but the FCC's definition does not exist anymore.
Well, that's good then. I mean, that's It sounds like a win for us small ISPs that now we don't have to follow all these rules that were very complicated and restrictive.
That's correct, but understand you still have to have a privacy policy by law, federal law, and if you're in California, California is the only state in the union that requires every commercial business that has a website or an online service, and that includes apps, to have a privacy policy. And California considers its definition of doing business in California is very broad. So it doesn't mean you have to be located in California. It means you have to be able to reach a resident of California. And that resident of California could be anywhere in the world.
Gotcha.
Isn't that lovely?
So you need California caveats in your privacy policy. Is that what you're saying?
Well, California has some basic requirements. You really don't need, it's not unusual. It's not out of the norm. The only thing that they require that no one else requires is for you to say whether you honor someone's request to do not track them. There are several different websites and services that a consumer can log into and basically opt out of tracking analytics. Like the National Advertising Alliance and some of the other ones. You have to basically say in your privacy policy whether you honor that request or not. It doesn't require you to honor such requests. You just need to say whether you do or not. But I think it's helpful for me to just go through first some of the basic requirements. And that's the same across the country, whether you're in California or whether you're in New Mexico or whether you're in St. Louis, it doesn't matter. First of all, the privacy principles for ISPs. And again, this is not binding on individual WISPA members. We strongly encourage you to follow these principles because I can assure you with Congress's dissolution yesterday, the consumer groups are up in arms and they will police and track as well as report violations. They are really upset that these privacy rules have been wiped off the books. So you're going to have a more active privacy bar, consumer bar than before. That's the bad part of this. The good part is if you follow basic principles, you should be fine. First principle that the ISP privacy principles is transparency. That's why you need a clear, comprehensive, accurate, and continuously available privacy policy. Meaning it's posted on your website. It's posted on your, whether it's a link in your app. If you make available in hard copy, if you deliver it with a contract or your terms of service, terms of use to your subscribers or customers. Consumer choice. Consumers should have a choice of how you use their data if it's for marketing purposes and it's being shared with third parties for marketing purposes. How you use, how you use that PII for delivering the service, obviously they shouldn't have a choice of that. Otherwise, how do you do your job? How do you deliver the service? So that's based on the FTC's framework, which is if it's first-party marketing, that should be fine. You can use your customer data. That includes their name and address and IP, any other type of PII that's applicable to broadband for your own network delivery, your own first-party marketing. But if you sell it or share it with a third party outside of providing your service, that's when they have a choice. Now, whether they have a choice to opt out of that choice or opt in, that determines how you want to run your business. Data security. Because you are a common carrier, and you are still a common carrier, I cannot emphasize enough that the repeal, the dissolution of these broadband privacy rules does not change the net neutrality order. I mean, granted, we're working on that, but that's still the law right now. So as a common carrier, you have to offer data security practices that are just and reasonable. Again, a reasonable measure, it depends on your size. It depends on your technical feasibility. It will depend on what type of data you collect. If you only collect IP address and you don't collect any other sensitive information like driver's license, social security number, credit card numbers, you're not doing credit card e-commerce transactions online, then you've got a different standard of data security than you would with less sensitive data. And then data breach notifications. You are still subject to notifying consumers under certain circumstances. 46, I think 47 state laws have data breach requirements. And if you are voice over IP, the repeal of these broadband privacy rules means the old rules stay in place. It means that you still have certain obligations to do the data breach security notifications under the voice over IP rules from the CP&I rules from years ago. So those rules are basically back to where we started from before this whole broadband privacy rulemaking started. Those are the fundamental things.
Gotcha.
Quick things. Oh, any questions?
No. We're good.
Excellent. Let me just talk about some of the detailed stuff in a privacy policy. I mentioned what you collect, how you use it, who you share it with. And I'm going to give you what the California rules require, because that's like the base standard. That's what everyone has been following since California. That's the only law that's in place, but California is basically the de facto national standard. And if California law follows the FTC requirements as well. So the basic is list of the categories of PII that you collect. PII meaning name, address, email. Do you collect browser information? Do you collect history? Do you collect email address? Do you collect domain name? What do you collect? Why do you collect it? List the categories of third parties that you share that PII with. And that means if you're using an internal for service support, a vendor, like a billing payment agent. There's a lot of WISPA members that use billing operators, billing service providers, third-party vendors. If you're using one of those, you don't have to mention them by name, because you may want to have the flexibility of changing out that service provider, changing a contract, but you do need to disclose what type of third party are you doing business with. And I call them operational service providers. They're providing internal support for you to offer the service. That's perfectly fine. So mention if you use billing providers, if you mention content providers, any third party, list them by category and how you share the information. If you're sharing it for marketing purposes, you need to say so. And you need to be upfront about sharing it for marketing purposes. As long as you disclose it, and then you want to give the particular consumer the right to either opt out or opt in, depends on how you set up your business. You need to share that too. I also encourage a statement in the privacy policy that says that consumers cannot opt out to certain types of disclosures to third parties, such as an OSP. That you just say right up front that you do not have the right to opt out of any PII used to offer the service to you, provide their service to you. That way, you have managed a consumer expectation, and this consumer knows that you will be using a third party for those services.
Question.
Yes.
So things are going in my mind of third parties that I use. I use a billing system that's third party. So in my statement, I would say you cannot opt out of use of our billing system. Our billing system is accessed by that provider as well as us, and we use it to run our business. And this is something you cannot opt out of, because we do collect, name, address, telephone number, email. I don't go after Social Security, driver's license, kids' information, none of that stuff. Right. Mm-hmm. But in this case, I would want to put in there, by accepting this service, you cannot opt out of the billing service, because this is a third-party billing solution.
I don't even think you need to be that specific. I think you can say we use independent third parties to support our internal operations and provide a service to you, such as billing and payment, and have the list. You do not have the right to, or you cannot opt out of these third parties.
Perfect.
Make it plain and simple. But Thanks. You've disclosed it up front. Again, you don't have to mention their name, because that way it gives you the flexibility of engaging a new third-party billing provider in the future. And that means you don't have to change your privacy policy.
Okay. Thank you.
Sure. One of the other categories is you want to include the types, as I mentioned, PII, but also you want to describe how you use that information. If you use, again, web browsing history or app usage for your own first-party marketing or for network management or for troubleshooting, just say so. You also need to describe the process by the consumer can change or review their PII. If you keep a database or a profile of consumers. I know a lot of WISPs will also have a account online for a subscriber that they can go into and register, or that can access their service and see their uses, see their data, allowances, whatever. If you give the consumer the right to change or update their PII, which you should, because you want to make sure the email address is correct, their billing address is correct. You want to let them know that they can review and make changes. But you also need to have a verifiable process in place so no one else can just go in and make those changes, which means you may want to send them, once they go into that account, an email that you have updated your account as of such a date. But you need to describe how that process is in their privacy policy. If you make material changes in your privacy policy, you also need to identify how those changes are being made. And a material change basically is a change that changes the rights and responsibilities of that consumer. Or if you're adopting a new service and you have now instituted a whole different set of protocols for the collection of PII. Or that you have changed owners even. If you have been bought out, if you now have a new operator that's providing the services, that's a material change. So you want to describe in your privacy policy how that consumer will be notified of a material change. Ideally, it's directly to the consumer, whether it's to email, but if you don't have an email address, obviously you're going to need to notify them somehow. You can certainly have a link on your website or a posting on your website, or send it to them in the bill if you have a paper bill or electronic bill. California also requires the effective date of the privacy policy, or when it was last revised. That's important because that sets up a whole series of record keeping. Here's why that's important. Consumers, when they agree to your privacy policy, you have now created a contract with them. And when you change that privacy policy, you have got to get their opt-in consent to changes. So you'd want to know which consumer addressed or adopted or agreed to what privacy policy. So you want to have some kind of date so a consumer knows this was effective as of such a date, or if it was revised yesterday. I've been a subscriber of yours for 3 years. They know that that's a new privacy policy. So you need the effective date.
There you go.
Now, also, I would suggest, and I've seen this, I can't tell you how many times, I know that our WISP members want to protect consumer privacy. So they'll have a statement that says, we value your privacy. We will not share your personally identifiable information with anyone. That gives me some concern. Never say never, because you will. You will not only share it with your operational service providers, you will share it with law enforcement if there's a due process criminal investigation, or if there's a wiretapping or some kind of CALEA access. You will share it with the FCC if indeed there's a issue with investigation or an administrative issue with the FCC. You'll share it with the Digital Millennium Copyright Act infringement claim, where you have to share the infringer's name and information with the copyright owner. You'll also share it if there's a security breach investigation or notification. You share information in the ordinary course of business with all kinds of third parties. So don't say you won't share it, because that in and of itself is misleading and could lead you to a deceptive claim, unfair trade practice claim on a state level and on a federal level.
There you go.
So never say never. Make sure that that statement isn't on your website. I've seen it in some of the advertising and promotional materials. Not just in the privacy policy, but I've seen it scattered all throughout certain documents. That's the other thing. You want to make sure that what you have on your website, your transparency standards under the 2010 Internet Order, your terms of use or terms of service, whatever you call it, all of those are consistent with how you do your business. That brings me to another thought. I can't tell you how many clients have borrowed someone else's privacy policy and just plugged it in on their website. I'm not going to say that that's a bad thing, because I know it's tough to write one, particularly if you don't want to hire legal counsel. But borrowing, if you're going to borrow someone else's privacy policy, I encourage you to do a couple things. One, read it first. Change the name. Oh my gosh, I can't tell you how many people have someone else's privacy policy. The opening paragraph has their company name, but the rest of it has where they borrowed it from, their name. The reason why you want to read it is because it may look good on its face, but it may get you in trouble. Your actual practices is what should be reflected in your privacy policy. If you are using someone else's privacy policy, they are reporting on their business practices. Of course, unless they borrowed it from somebody else. But you really want to make sure that what you say in your privacy policy is accurate and it reflects your real business practices. Otherwise, you get back to that deceptive, misleading part. You are then subject to deceptive trade practice. That's under the FTC or state laws, but under the FCC, because you are a common carrier, you're still subject to enforcement actions under 201B for unjust and unreasonable practices. So make sure your privacy policy reflects your unique business and your unique style. Any questions?
That's funny you bring that up. Read the darn thing and change it.
Yeah, at the very least, if you're gonna steal somebody else's, at least change their name off of it.
See, I said borrow, you said steal.
Hey, whatever floats the boat. But yeah, I mean, I can easily see where people, and I've seen this many times, where you make a privacy policy and you take it from another website or something like that. Because guess what? You have to post it somewhere.
Right.
And you end up with what you have is what you get, is what they say. So,
Indeed. The other thing that California law requires, but this is also embodied in FTC practices, as well as FCC when it comes to clear and conspicuous disclosures, that privacy policy, there's usually a link at the bottom of a website. That's usually where you find the privacy policy. California law requires that link to be in a different font or style than the other links, or color than the other links surrounding it. So that way it stands out. And certainly if you've got it in a really, really, really small font, that would not be clear and conspicuous. So the FCC, FTC, California, and other states require you to post that privacy policy in a manner where people can find it easily. And again, that link should be in a different font, color, or style than the surrounding links. I also, from a legal perspective, encourage you to incorporate your privacy policy into your terms of use and terms of service agreement. That way, it's all one big legal document. They're separate documents, mind you, but if the privacy policy is incorporated by reference in your TOU or TRS, as well as your transparency standards, your copyright, infringement notice, all those things, then all those boring legal provisions in your terms of service, terms of use when it comes to disputes and jurisdiction and reps and warranties and all that, follow the other documents as well. So your privacy policies stand alone, but you want to make one large legal document per se when it comes to
You mentioned, mention that in your terms of service and acceptable use. What a simple statement in those two documents saying we have a privacy policy. Go check it out.
No.
Because that's included in those two documents.
Well, it is, but I would encourage you to do a couple things. One, to state in your terms of service that this terms of service incorporates by reference the following documents or policies, and then list the documented policies. If you've got it on your website, why not make the title of each one of those policies or documents a live hyperlink so people can go to it right in your terms of service and terms of use?
Right, that's kind of where I was thinking.
Okay. I also encourage you to, and here comes to the record-keeping problems. One of the biggest problems with I see for small businesses is you don't keep track of what consumer agreed to what privacy policy. You'll need to know that because you need to know what promises you made to that consumer and what date it changed. So you need to have some kind of dynamic record keeping, whether it is through your online, if you're soliciting subscribers online and they're actually registering online, that the date that they sign up to your service, there should also be an affirmative click box, a click through that has a box or some method for them to affirmatively hit the mouse and hit check or put their signature, electronic signature on it, that indicates that they have, and here's some language that may be helpful, by my submission or by my registration, by my consent to be a subscriber, however way you want to frame that, I hereby confirm that I have read, understand, and consent to, name of your company's, terms of service, privacy policy, and any other document you want to include there. That way you've got a record that they've said that they have read, understand it. Now, you're not obligated to make them read it, to double check that they've read it. That's what that affirmative statement does. Now, if they didn't read it and they checked it, how would you know? That's the best thing we can do, we can offer right now. So the affirmative consent part, that box cannot be pre-checked. I've seen that in a lot of website registration processes. It's already pre-checked. Even though the language looks like it was an affirmative opt-in, if it's pre-checked, it's not an opt-in, it's an opt-out. So they have to do something. They have to take an active step to indicate that they consented. That's why that affirmative click box is important.
Or like a signature on a iPad or something after you sign them up.
Signature, as long as there's a statement that's not just a signature to the service, that is a signature that they have read and understood and consent to the privacy policy in terms of use. So it's very clear, what did they agree to? The problem with just a basic signature at the end of several pages is what exactly did they agree?
Right.
Kind of hard to tell if it doesn't have that affirmative statement on there.
I want to go back to the language, we never, ever, 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 never sell anything.
I said, share your information with third parties.
That's the easy language. There may be a time where we would be forced to share your information.
Well, what I've seen is we never share your information, and I've seen you never sell it. Here's the other problem with the never sell language. What if you sell your company? What if you merge with another entity? Then you're selling their personally identifiable information. So in your privacy policy, there should be a statement that your personally identifiable information and your account profile or whatever you maintain and retain on a subscriber will be shared and sold to upon a merger, change in ownership, bankruptcy, dissolution. That is based on, I can't tell you how I first wrote that, I call the merger clause, was when several years ago, and this is when I was my first year in private practice, I had just left the SBA, there was a Toys Mart, which was a .com company, and the .coms back in the 90s, and now I'm aging myself, went up and went down in a flame, and Toys Mart was on the market for bankruptcy, and its only real valuable asset was its database. But in their privacy policy, it said, we will never share your information with anyone. And the FTC and 39 state attorneys general said never means never. That means that can't even be sold at bankruptcy. They sued that company. I think their legal fees were worth more than what the company was worth. So they had to, in fact, the database was purchased by, I believe it was a subsidiary of Walt Disney, which was an investor in the Toys Mart, but only with the consent of the bankruptcy court and FTC that purchased the database, but then had to destroy it immediately. So the one bankruptcy asset was not valuable anymore. So if you're looking at acquiring another company, looking at merging with another company, I suggest you look at their privacy policy first to see if you can even get their database, get their subscribers. It may prevent you from making a purchase. It will
Wow,
change.
that right there is extremely valuable. Wow.
Yes. Take a look at the privacy policy. See if their privacy policy will allow you to even acquire the basic fundamental email address, IP address, domain name, customer name, billing information. You may not be able to purchase that company as an ongoing concern. Their business is no longer valid. And understand, if you have that statement in your privacy policy and you eliminate that statement, and you will now add the merger clause and all the other ways that you're going to share with third parties, such as law enforcement, or if there's due process requests, court debate, whatever, that's considered a material change, because now you've changed the way a customer's rights and responsibilities are in their PII. So you now have to get their affirmative consent to that new privacy policy. That's why I advise never, ever, ever put that statement in your terms of use, terms of service, privacy policy on your website. It sounds as if you're being a good actor and you're being a good corporate citizen. All it does is hamper the ability for you to do business.
It handcuffs you.
Yes,
Yeah,
big time.
It does.
Big time.
So I'm a bad operator and I don't have my privacy policy up yet. Once I get that up on the website, do I send out through my third-party billing system a thing saying, hey, we've added a privacy policy, please go read it, and then sign here that you've read it?
Well, what did you have when you signed up your subscribers?
I just have an acceptable use policy and a terms of service.
But no privacy policy.
Correct.
No statements how are you going to use it. Okay, so that wouldn't be a material change. So I would send a notice that say that you have incorporated a privacy policy in their terms of use. And it details, and you could put a marketing spin on this, that it details how we will use, collect, and share your personally identifiable information. And are they paying online perchance?
Yes.
Okay, then it's helpful when they go to make that payment. If you have a system that the pop-up box comes up that says we've updated our terms of service and added our privacy policy, and have that affirmative consent statement there, that way they have to click on it in order to get through to the rest of their billing and payment. That would be helpful. If you have a website, it'd be great to post it on your website. Hey, we've got a new privacy policy. Check it out.
Yeah,
You can do that.
So something else, Steve, is your billing system. I know Visp uses Hotspot, okay? So something that Visp could do is they could actually allow you to upload your privacy policy, and then basically you send out that statement to all your users. And then if they do not accept it, all of a sudden they get the splash page. And now they have to accept it, or they have to deny it. They have to do something with it to get back online.
Mm-hmm.
So you might want to check on that.
Yeah. Does your terms of service say that you can modify and update their terms of service?
Absolutely.
Okay. If you've got that provision, this is deemed to be an update to the terms of service that they have to agree to. So that way you can install and implement the privacy policy much easier. If your terms of service and terms of use does not allow you to change their terms, that somebody will have to call me and pay me for that, because I'm not giving away that information for free. A girl's got to eat.
There you go.
It just gets more complicated. It's a very detailed process. It depends on what else you have in your terms of service. We'd have to look at it and try to find a way how you can require a consumer to agree to something they didn't agree to when they first subscribed to the service. That's why you want your privacy policy in place now. That's a more detailed and a very specific and particular legal analysis.
Okay.
There you go.
But that's why your terms of service and terms of use also controls how you implement your privacy policy sometimes. So it's helpful. You want to give yourself as much flexibility as possible. And in terms of timing of a privacy policy, for example, if you're looking at right now, you're only doing first-party marketing. That means that you, the provider, you're using a customer's PII for your own use, for marketing and upgrading your service. If you're moving to VoIP, for example, you want to be able to contact your internet folks and let them know you are now adding a voice service, or vice versa. you can use that information for your own purposes, first-party marketing. But if you think you want to move to third-party marketing, which is now sharing that data with a third party, and you're going to do it within the next 6 months, you may want to have a privacy policy that gives you the flexibility to do that, as opposed to having to change your privacy policy and then send out a whole new affirmative consent. You may want to put provisions in there that give you maximum flexibility. Same things in your terms of service, terms of use. As long as these things are not deceptive, that you haven't said you're going to do one thing and then you do another, you can have projected use of PII as long as it's as specific as you can make it, and hopefully you can give a time frame when that's going to happen.
Wait a second. From what I was gathering, you want to kind of keep it vague, but you're saying make this specific?
Well, for example, if you're looking at doing third-party marketing, that, for example, or using aggregate data to sell to third parties, you can state in your privacy policy that we plan over the next whatever 6 months, 9 months, to be able to aggregate personally identifiable information and sell it to or commercialize it to third parties. You don't have to mention the third party name. You don't have to mention which type of PII you're talking about, but you've put a holding statement in there that basically says you're going to be able to do that, that you're planning to do that within I'm not talking about in 30 days, but maybe a range of time that gives you some flexibility. If you have zero statement to that effect in your privacy policy, when you start that aggregation, that sale, you now got to go back to everyone to get their approval to do so. But you've
So that's where you would kind of keep it vague.
General. Let's call it general.
General. Thank you.
Yeah. You have to use the right word here.
I forget I'm talking to an attorney.
Yeah.
and a salesperson. Again, I'm marketing and sales, 16, 17 years on the advertising side of it. And again, that's what drove me to law school, because I had some FCC rules that just made my life miserable as a sales manager. And I didn't understand the FCC process. And now that I've clerked for 2 FCC commissioners and been a senior staffer in the Office of Communications Business Opportunities, I still don't understand the FCC. It's driven by politics. It's driven by a whole lot of other things. But I have a better idea of what doesn't work at the FCC. So,
Gotcha.
That's just as good, if not better.
Gotcha. Well, we do not have any questions for Jenell as of yet. We actually have quite a few people online listening in. We appreciate everybody from coming on in and listening to this. I guess what else do you have, Jenell? Do you have anything else that we have to know?
I have a couple things, yes. One, I have an article that I co-wrote with the California Office of Privacy Protection. It's in entrepreneur.com. A little show and tell that says I've got my article printed here. It's called Customer Privacy Policy Essentials. Although it's dated from May 2013, it is still accurate. This is a good, quick, easy primer on what to include in your privacy policy. I encourage you to go to entrepreneur.com. We will also, as in Steve Coran and our firm, will send out those internet privacy principles to all the members today to remind them that these are the principles that they should follow. We strongly encourage them to follow those because that's what has led to this CRA, the Congressional Resolution Act disapproval. And this is what we have shared with the chairman's office, that consumers are still protected even though the FCC broadband rules are not there. And something not directly related to a privacy policy, but I do want to remind everyone, I'm trying to tell as many people as I can, that under the DMCA, that's, Dennis, this is your favorite statute, the Digital Millennium Copyright Act, if you have a designated agent registered with the Copyright Office, this is the safe harbor, that's by statute, that if you have a DA registered with the Copyright Office, designated agent, then you are escaped from liability when it comes to third-party copyright infringement claims. The new rules with the Copyright Office are in effect now. You now have to register electronically. And if you have a DA agent, you need to re-register that designated agent electronically before December 31st of this year. Otherwise, you will lose the safe harbor. The other new rule with the Copyright Office is your registration with the Copyright Office and your disclosures on your website as your DA agent and contact information have to be identical. They both must be accurate. Otherwise, you lose your safe harbor. The last thing with the DMCA new rules is the Copyright Office realized that a designated agent does not have to be an individual. It can be, but you can also designate a position, a department, or a third party. For example, I have served as the designated agent for thousands of radio stations across the country. So now you can designate a department. I suggest not doing an individual because you want to have multiple people to keep track of what kind of complaints, if any, come in. But I can't state enough that you need to re-register what you used to file on paper, now via an electronic process with the Copyright Office, your new designated agent information. And all that information is on the Copyright Office's website.
Jenell, quick question. You said you're going to send out an email with what we just went through about the principles of the privacy policy. Could you also include in that email the entrepreneur.com link? Because I'm sure a lot of our listeners would love to read that. And also the link about the designated agents issue, if you wouldn't mind.
The designated agent stuff, we may just do a separate notice on that for everyone.
Okay.
Because I'm working on a firm memo for that, and we can share that since I didn't want to get the two confused. But my entrepreneur.com article, I'll see if Steve can do that. I'm not sure where he is with the email. We were trying to get that out early this morning.
Wonderful. I mean,
but if you Google my name, Jenell Trigg, and put in entrepreneur or customer privacy policy essentials. In fact, if you put just the word customer privacy policy essentials, it'll come up.
So,
okay, gotcha.
Jenell, we have one question. Can you give an idea of what you would charge a typical WISPA member to write a proper privacy policy?
Depending on the size and depending on how complex your business practices are, we're working on a flat rate that could range from anywhere from $1,000 to $2,500. That includes looking at auditing your privacy practices, making sure that you say what you're going to do, as well as that what your collection of information, where you are in terms of sharing with third parties, whether you can share or can't share. So it will depend on the complexity and the size of the WISP.
Gotcha. That sounds excellent. Not a problem.
So if these folks that were interested in hiring you or Steve to put this together, how would they reach out to you to do this? Because, it would save a lot of people a lot of grief, I'm sure, than going and borrowing someone else's policy and having to go through and parse it.
Send me an email or give me a telephone call. I'm strigg@LermanSenter.com. Or if you put in LermanSenter, our website comes up. Steve's photo is there, my photo's there, our bios are there, as well as our contact information. Or if you want to contact Dennis can forward you, or Steve can forward you to me. We'd be happy to help.
Wonderful. Well, this has been an outstanding show. I've been writing down all the notes that I got here, and I can't wait to see the email. But just a great show, and I appreciate it. Like I said, I'm a bad operator and don't have the privacy policy out yet, but we're working on it, and it's something that's been gnawing on me since last year's WISPAPalooza and seeing your presentation at that show.
Well, like I said, as a common carrier, as a telecommunications carrier, and that has not changed given the congressional dissolution of the privacy rules, you are required to have a privacy policy. So we'd be happy to help. Good luck. Be careful out there, everybody.
Well, Dennis, are there no other questions out there?
Nope. I think we got all the questions that they had asked.
I think we have covered everything in privacy policy that is fit for a radio show. But if you guys have any other questions, definitely reach out to LermanSenter. Jenell would be happy to help you out if that's the path you want to go. Looks like next week we're looking for another interview, but I want to thank Jenell and Dennis for doing the show. And Dennis, if you want to wrap us up, we'll see you guys all next week, I hope.
Excellent. We will hopefully see everybody next week, and we will wrap up the show.
Take care, everyone.
Thank you for listening to ISP Radio. We hope you've gained new insights and additional wisdom in our industry as well as your business. Please remember to visit our show sponsors via the links on ispradio.com. If you're interested in becoming a show sponsor, contact us at sales@ispradio.com. Now go out there and push those packets as fast as you can. Good luck and Godspeed.